Let's talk about the actual statute itself as far as the liability portions of it. As I stated before, this is a consumer-driven lawsuit, but it's really geared towards consumer lawyer-driven lawsuits, because the real benefactor of these types of cases is not necessarily the consumer, it's the consumer's lawyer. And the statute was specifically addressing getting people motivated to bring these types of suits and being rewarded if they prevail and protecting the client and stuff like that. So the statute's set up in certain different ways for that very purpose. However, one of the parts, since this was enacted in 1977, that has not changed since that time period, is that the statutory damages that are awarded under the FDCPA is capped at $1,000. It's not the same $1,000 as it was back in 1977, and I think the consumer bar has made several pushes to try to change that, to increase that for practical purposes and to increase it for inflation to make it more meaningful. However, this $1,000 statutory damage is a sliding scale. It's not necessarily $1,000 no matter what. It's based on three factors. And the court needs to determine if there is found to be a violation to consider a couple things. Number one is the frequency of the violation, the nature of the noncompliance, and the extent to which the noncompliance was intentional. So really, when you're looking at statutory damages, the value could be somewhere between $1 and $1,000, depending on the severity of the count. Certainly, a letter failing to contain the mini Miranda is going to be far less in value than some harassment where there's name calling or abusive language or some other tactic that's far more egregious. So when you're trying these cases, there is a determination. Now, practically speaking, when you talk to consumer attorneys, they just want the $1,000. They want the maximum. It's given the fact of the low value of that. So, but understand, practically, when you go to trial, the jury instruction is to allow the jury to determine the value of the statutory damages based on those three factors. Let's talk about, I got a question regarding caps and stuff. The next question is, can you discuss the relationship between state and federal damage caps, specifically under the FCCPA, and the effect of the Beaters case and subsequent changes to the FCCPA? It's a great question because this is actually my case, and it's important for this. There's a difference between the Beaters case was actually a case in which damages were associated where there was multiple violations claimed to be by the frequency of phone calls. So basically there was a series of phone calls that were made where there was a violation by failing to provide a disclosure, but the phone calls were separately made. So in the case was the fact is that they tried to make separate claims for each phone call as a separate violation. The court consolidated that case and said, in federal court, it's the cause of action. So the statutory damages are capped at $1,000 per case, not per violation. And that's based on the Harper Better Business Bureau case, which is an 11th Circuit case. Under our state statute, as it was in existence prior to 2010, we had a different form of calculation and just said upon adjudication of that matter, you could get $1,000. It was not particularly clear, but our state statute said we should follow any case law as binding or at least highly persuasive of a federal nature. The Beaters case basically said under the old version of the statute, it could be deemed a violation if they were separate violations or adjudications of liability. That statute, after the Beaters opinion came out, the legislature amended the statute to equal or basically track the FDCPA in its liability search. So the determination as to whether or not the amendment of the FCCPA now creates the same aspect of capping $1,000 per case. And recently there's been opinions, including a recent federal opinion that said, yes, it's $1,000 per case, similar to the FDCPA. So that aspect of $1,000 per violation under state law has been resolved legislatively by the change in the statute, and also case law that is interpreted after that it's $1,000 per case, similar to the FDCPA. Actual damages under the FDCPA. In reality, I don't see a lot of plaintiffs' lawyers bringing actual damages claims as much as they used to. And I don't know why, but I fathom some guesses as to why. I usually see actual damages in the form of monetary out-of-pocket damages that may have been occurred through credit bureau reporting. There are some aspects of the FDCPA, if there's issues in which there's been credit damage, they're trying to collect a debt that's not legitimate, it's not their debt, or it's been disputed, it goes on the credit bureau, they're collecting a debt, and one of the damages is that they have a lower credit score, or they've caused some kind of economic harm where they were unable to get credit, or they have a higher interest rate because of the differential. I generally see actual monetary damages in that. They don't normally have out-of-pocket damages in any other source. Mostly actual damages are characterized as emotional distress damages under the FDCPA. So you'll see claims for instances of emotional distress, or loss of sleep, or anxiety, or humiliation, or embarrassment, and those aspects. And so they're couched that way. But I really see a diminution of loss in them bringing those types of claims, because it opens up a whole nother realm of inquiry into the litigation as to supporting an actual damage claim as to the emotional or mental condition of the consumer. It may get into personal issues involving the consumer as far as stress or maybe other debt collection calls. So I've seen a retraction recently in merely the plaintiff's lawyers seeking just statutory damages plus reasonable attorney's fees, and really somewhat putting the actual damages aside as far as actual damages. So I really don't see actual damages coming too much into play, but it's still a big consideration given the fact that actual damages are unquantifiable. If you have a sympathetic plaintiff, particularly as far as the level of harassment, if it's verbal or whatever the characterization may be, you can't quantify it, and it may be up to a jury to decide what level of damages will be assessed for the fear or inconvenience or humiliation that they're claiming that happened during the debt collection attempt. So it still exists. I don't see it as much, but it could be a problem because it could be unquantifiable. Under the FDCPA, there's no punitive damages. So claims for punitives or anything like that don't exist under the FDCPA. However, some states, particularly in Florida, have a punitive damage section as well that needs to be considered under that state statute. So you may have other states that have punitive damage awards that may be coupled with this, but under the FDCPA, there is not a punitive damage entitlement, nor is there an entitlement to injunctive relief, which I find strange. Our state statute does have injunctive relief to stop the alleged conduct that is being done, is incorporated in our Florida statute, but not in the FDCPA. The FDCPA does have declaratory judgment, but that's hardly ever sought for, because really these cases, like I said, are given towards finding a violation and obtaining attorney's fees or some type of settlement prior to litigation. The FDCPA does have a class action damages section. If a class is attempted to be certified, the measure of damages is $1,000 to the class representative, and then the class members themselves, the determination is based on $500,000 or 1% of the debt collector's net worth, whatever's less. So there's a $500,000 cap on damages as far as a class, or what the net 1% of the net worth, which is probably 99.9% of the time it's going to be whatever the net worth. And these are evaluated, generally speaking, based on what the debt collector's assets minus liabilities calculation would be times 1%. Could be nominal amount of money. So we see situations in which there's large class sizes, particularly in letter violations or alleged violations, where there's a large class size with a nominal recovery to the class given the net worth. and that kind of prompts some settlement discussions as well as different ways to resolve a class action lawsuit on behalf of the class without having to rely on the net worth calculation. Sometimes classes are set up where the net worth calculation is even offered as a side prey distribution to particular members, but not necessarily valuable. Some agencies may have valuable net worth that may cause some issues on the larger agencies, but generally the collection agencies have a modest net worth that is of an interesting concern when you're defending these cases on how you come up with a resolution.